I want to welcome everyone to Washington Legal Foundation's media briefing. My name is Glenn Lambie. I am Vice President of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 45th year of free enterprise advocacy, education, and communications. We are very, very active in the Supreme Court. I'll mention a little bit about our activity this term. This is the 34th year, I believe, that we've been doing this particular program, wrapping up the term at the end of the term. We've been blessed over the years with a good number of different appellate advocates and Supreme Court experts. Pleased to have three with us today. I will introduce them momentarily. In a term teeming with blockbuster decisions, WLF and other organizations that focus on economic liberty and the rules for business conduct had to wait until the very last day of the term for the big wow decision. West Virginia versus EPA provided that case, but as is often the case, lower profile business decisions just may have as much ongoing impact as that 63rd published opinion. We're here to talk today about some of those unappreciated rulings, about West Virginia, of course, as well as the bigger picture themes and principles that emerged from the court this past year. WLF was typically active in the court this term. We filed a total of 25 amicus briefs in both merits and certiorari stage cases. We filed twice as many at the cert stage than we do at the merit stage, and 5 of those were successful in helping to convince the court to accept the case that we were supporting for review, which is a pretty good batting average when you look at how many petitions are filed and how many cases the court decides. I want to introduce our panelists first. Also let you know that if you want to ask a question during the program, you can click the Q&A button and type in your question, and then we'll read that out when the time comes. Share my screen here real quick. So joining us today is Shay Dvoretzky, who heads the Supreme Court and Appellate Litigation Group at Skadden, Arps, Slate, Maher, and Flom, and is based here in the DC office. He represents clients in a wide range of appellate matters in the U.S. Supreme Court, federal courts of appeals, state appellate courts. Shay clerked for Justice Antonin Scalia of the U.S. Supreme Court and Judge Michael Luttig of the U.S. Court of Appeals for the Fourth Circuit. Joining us also is Morgan Ratner, who is a member of Sullivan and Cromwell's Supreme Court and appellate practice. Prior to joining the firm, Ms. Ratner served in the office of the Solicitor General at the U.S. Department of Justice. During her tenure there, she argued 8 Supreme Court cases involving areas of federal law as widely diverse as securities regulation, bankruptcy, employment, intellectual property, criminal law, and elections law. She clerked for Chief Justice John Roberts and for Judge Brett Kavanaugh of the U.S. Court of Appeals for the D.C. Circuit. Finally, Amy Saharia is a partner with Williams and Connolly. She represents corporate and individual clients in high-stakes appeals in the U.S. Supreme Court and federal and state appellate courts around the country. Before joining the firm in 2007, Amy served as a law clerk to U.S. Court of Appeals for the Second Circuit Judge John Newman, and she returned to Williams and Connolly after clerking for Associate Justice Sonia Sotomayor from 2010 to 2011. I'm going to ask each of our panelists in alphabetical order to get us started with a brief statement of what their thoughts are on the court, and then we will proceed sort of with a question and answer approach. Shay?
Glenn, thanks for having me. As Glenn mentioned, West Virginia versus EPA, along with, I think, American Hospital Association versus Becerra, those cases have gotten a lot of attention for the court's administrative law docket this term. Obviously, there were lots of other hot button decisions in other areas. Apart from the administrative law cases and the 5 arbitration cases, some of which we'll talk about, that's a large number of arbitration cases, this was a relatively slow term for business interests at the court. I also think looking ahead to next term, the court's core business docket in areas like securities, intellectual property, federal preemption, those sorts of core business issues is quite light. And so I think one of the interesting things to me about this term, obviously it's been widely reported that this is the term in which the court's conservative majority really started to flex its muscles. At the same time, the court's business docket, setting aside again administrative law and arbitration, has been quite a bit lighter than usual, even accounting for the court's overall lighter caseload. So to me, that's an interesting, as a practitioner who focuses mostly on business cases, that is an interesting and perhaps somewhat disheartening trend to see about the court, and one that I'll be watching to see if that continues or not.
So thanks, Glenn, and thanks WLF for having me. I think that we can all agree, and Shay just alluded to, this is not going to be the term that people think of as OT 2021. That's the term the court extended, that copyright mistake of fact defense to mistakes of law. It's going to be the term of abortion and guns and climate change, maybe vaccines and religion. And so I do just want to say at the outset that although we're going to be focusing on some of the more classic business cases, I think it's really a mistake to draw a firm line between the hot button political cases and the business cases. I think we're going to see pretty significant repercussions for businesses flowing from those decisions. So let me take abortion, for example. What we're going to see next is states that have different rules on employer benefits plans. Employers have to cover abortion, employers can't cover abortion. Are employers who do cover abortion subject to criminal liability for aiding and abetting in certain states? In other states, can judgments against those employers who have aided and abetted be executed on because of the law in those states that prevents such judgments from being executed on if they come from if you're in a pro-abortion state and they come from an anti-abortion state? And what are the full faith and credit implications there? What are the implications for ERISA preemption? I think there's going to be a host of questions that businesses will face as a fallout from these, seemingly more political cases. And that's just abortion. We're also going to have, I think we're seeing now an increase in what I think of as kind of like boycotting laws. So states that are giving preferential treatment or excluding businesses that may not have certain political, may not adhere to certain political beliefs or organize their businesses consistent with a certain political belief. They may not be eligible for state business in a variety of ways, state contracts, or maybe sometimes investing state pension funds, things like that. And so, we're going to talk on the sort of true blue business cases, but I just want to emphasize at the outset that I think it would be a mistake to really try to separate these political issues and not also be thinking about the business repercussions that are going to stem from those as well.
Thank you, Morgan. Amy?
Hi, everyone. Thanks so much for having me. I think an interesting question will be the extent to which the court's kind of rapid movement towards the right on these big social issues will or may not kind of bleed over into the key business cases. And it's a little hard to know that because, as we've heard, the business docket was so light this year. As we'll talk about later today in the big admin law cases, the court, did reach a fairly business-friendly outcome in the West Virginia case, but it didn't go as far, it didn't reach as bold of an outcome as it could have. And so it's a little hard to know whether the speed with which the right is moving to the right on the social cases will influence business cases going forward, or whether it might not. We'll talk about the arbitration cases. They were a real mixed bag this year, and so I think an open question remains kind of how this is going to go forward next term and the terms that follow on the business side of things.
Thank you, Amy. It's a good way to end your statement, because we're going to start our discussion on the issue of arbitration, which is an area the court's done quite a bit on for the last 4 decades. As Shay said, they took 5 questions this term. I want to ask a sort of a general question first, and then dive into a couple of the decisions. So the court has expressed in the past through its decisions that the Federal Arbitration Act advances a federal, quote, policy favoring arbitration. Shay, will that phrase still carry the same force in future cases after the court's decisions this term, especially Morgan versus Sundance?
So as Amy said, it's been a mixed bag this term for the arbitration cases. And I think the pro-arbitration policy that the court has previously articulated arose in cases that really dealt with big picture questions about arbitration. And I think some of what we saw this term with the high number of cert grants is now that those big picture principles have been established, we're getting circuit splits about technical implementation questions. What kind of showing is required for a waiver of arbitration rights? Who's a transportation worker for purposes of the transportation worker exception? These are more operational, ground level sorts of questions. And I think in that context, the pro-arbitration policy that the FAA, that the court articulated in some of the bigger picture cases about arbitration has carried less weight. I also think as a general matter, this court is not that the court was not a textualist court before, but this is really a textualist court that we have now. And so I think that they are just much more focused on the particular issue before them and what the statutory text says about it than having a thumb on the scale one way or another, either pro or anti-arbitration. In terms of Morgan versus Sundance in particular, so a little bit of background on that case for those who aren't familiar with it. The court there held that federal courts cannot adopt an arbitration-specific rule that conditions a waiver of the right to arbitrate on a showing of prejudice. So the plaintiff in that case filed a lawsuit on behalf of herself and others against Sundance, claiming that Sundance had failed to pay overtime wages. Sundance litigated that case, I believe, for about 8 months. And after about 8 months, asserted the right to arbitration under the plaintiff's employment agreement. And the question was whether that 8-month delay waived the employer's right to arbitrate. The lower courts said that in order to show that waiver of a right to arbitrate, the plaintiff would also have to show some prejudice as a result of the delay. And the Supreme Court unanimously rejected that and said the FAA just doesn't authorize courts to create special arbitration-specific rules, pro or anti-arbitration, one way or another. And usually, as the court said, a federal court that's deciding whether a litigant has waived a right doesn't ask about prejudice. The court's ruling is quite narrow. It made clear that the equal footing rule for arbitration doesn't let courts disfavor arbitration, but it also doesn't let them favor it either. And the court left open a lot of questions in this case about which contract law doctrines even apply when you're asking about waiver. Is it a waiver doctrine? Is it forfeiture? Is it something else? Do courts look at state law or federal law in applying those doctrines? So I think this was a very narrow decision that just said the equal footing rule cuts both ways.
Talking about statutory interpretation and sort of textualism, another arbitration case that sort of came down to that, probably more than whether the court's pro-con arbitration was the Badgerow versus Walters decision. Shay, why don't you tell us a little bit about that as well?
Yeah, Badgerow versus Walters, I actually think is potentially a more significant case in the arbitration space than Morgan versus Sundance. The question in this case was whether federal courts have subject matter jurisdiction to confirm or vacate an arbitration award under sections 9 and 10 of the Federal Arbitration Act. In an earlier case, Vaden versus Discover Bank, the Supreme Court had held that under section 4 of the Federal Arbitration Act, a federal court has jurisdiction to consider a motion to compel arbitration if the underlying claim raises a federal question. And so the question in Badgerow was, after the federal court has compelled arbitration and the parties proceed through arbitration, if one party at the end then wants to move to either confirm or vacate the arbitration award, where does it go? Can it go to federal court for that, or does it have to go to state court? The Supreme Court, 8-1, with only Justice Breyer dissenting, held that there is no federal jurisdiction at the end of that process, even though there is federal jurisdiction to compel arbitration at the beginning. And this was a straight textual analysis. The court held that the language that is in section 4 that creates jurisdiction over a motion to compel just isn't there to provide jurisdiction over a motion to confirm or vacate. As Justice Breyer pointed out in dissent, this doesn't make a whole lot of sense Doesn't make a lot of sense for the federal court to start out the process, but then not have jurisdiction to review the award that results from it. This is also potentially problematic for businesses who will now have to face state court review of arbitration awards, and that may reintroduce the very same state court hostility to arbitration that Congress meant to eradicate in the FAA by putting arbitration, to use the phrase from Morgan versus Sundance again, on an equal footing with other contracts. So I think this case is potentially more significant than Morgan. But again, it shows that this is a very textually focused court, much more so than a policy-oriented court.
Amy, the court also addressed an exception written into the FAA for quote unquote transportation workers in Southwest Airlines versus Saxon. What will the broader import of the court's decision there be?
Sure. This is another example of the court adopting a very textual reading of the FAA in a way that came out against arbitration. Just as background, the transportation exception to the FAA exempts from compelled arbitration contracts of employment of seamen, railroad workers, or any other class of workers engaged in foreign or interstate commerce. The question in the case is whether an employee who loads cargo for Southwest Airlines is a worker engaged in interstate commerce. The court said yes, that looking to the text of the FAA and the broader textual context, the court held that cargo loaders such as the plaintiff qualify for the exemption because they are intimately involved in the moving of cargo across state lines, even though they themselves don't cross state lines. And notably, the court rejected Southwest's invocation of the pro-arbitration purpose of the FAA as a reason to read the statute in its favor, finding the text to be clear and therefore no reason to apply a pro-arbitration policy. I think the more difficult question is the one that the court noted in a footnote that it was not answering, which is, the ruling may be clear to people who work at, literally moving cargo on and off of planes that are flying in interstate commerce, but how does it apply to people like Amazon delivery drivers or Grubhub delivery drivers? The court cited two conflicting cases on that issue in a footnote and said, we're not touching that right now. But its reasoning certainly leaves open the possibility that those individuals would not be considered transportation workers on the ground that their job is, they belong to a class of workers who are essentially local in nature. They deal with products only after they have traveled interstate commerce and deliver products locally. But again, the court said it was not answering that question. It did say it was a harder question. I think one question might be, what about workers who live like here in DC and travel across state lines as part of their ordinary job? I think it's important to keep in mind that the court made clear that what you're looking at is the class of workers that a particular employee belongs to, not the job functions of that one particular employee. And so I think the focus needs to be on what the class of workers do on a daily basis.
The court had opportunities to address those Grubhub and Amazon issues in the last couple of years, and they unfortunately denied cert in those cases. So I guess they're waiting to see how those bubble up in the circuit courts. Let's end our focus on arbitration on a bit of a higher note for proponents of arbitration. The Viking River Cruises case involved a unique California law and a not so unique California decision not to enforce an arbitration agreement. Morgan, how much did these two aspects of the case factor into the court's decision to reverse?
Well, they couldn't hurt, that's for sure. But, frankly, do I think that they were driving it? No, I think the ultimate driver for the decision here was the fact that because of this unique California scheme, there wasn't a way to enforce an agreement between an employer and an employee to arbitrate a claim without bringing along a whole bunch of other claims that the employer did not agree to arbitrate. And, to take a step back, this case involves California's PAGA, or Private Attorneys General Act, which basically is a mechanism for claim aggregation. An employee can bring her own claim for violations of labor law or California's labor code, and the employee can bring the claims of other employees for different violations of labor codes and can lump that all together in one suit. And it's similar to a qui tam action in many ways. That's complicated by the fact that California law further said, well, you can't really break these two things apart. An employee who wants to act in this representative capacity also has to bring her own claim. And so if you're going to go to arbitration and you agreed to arbitrate, you got to bring all the other claims along with it. And the court obviously decided, that was not okay. The employer had not agreed to arbitrate with everyone. And so if it had agreed to arbitrate with that employee had to arbitrate her claims. And if that meant that the separate PAGA representative claims were not available in arbitration and that they could not be litigated separately, then sort of so be it. To that extent, the whole system would be preempted. But I think in many ways, whether this is a win really depends on whether California accepts the invitation in Justice Sotomayor's separate opinion, where she said, like, look, the issue here is that California has said these two things have to be linked, right? The employer's own claim has to go along with a claim in its representative capacity. But a state could choose it differently. A state could say anybody can bring a representative PAGA claim. And in that circumstance, there wouldn't be the same, at least in Justice Sotomayor's telling, there wouldn't be the same limitations. You would still have access to that sort of representative type suit. And so I think the big question for employers now is going to be, does California change its law, or do California courts change their interpretation of the law in light of the Supreme Court's decision? If they do, there are going to be some real policy concerns. I think if the response to this is to enact a law that says anybody, even without a claim, can bring a representative action and make a percentage of the penalty recovery against the employers, I think if that is the result of this, then the ultimate outcome for employers is going to be a lot worse, frankly, than under the existing PAGA system. So I do think the effects of this case are positive for businesses as the law currently stands, but there's really a risk there for maybe a worse situation than they had before.
Moving on to the administrative estate/regulatory areas, the court cert grants in cases like Empire Health versus Becerra, American Hospital Association versus Becerra, West Virginia versus EPA, inspired a good number of amici to write, hopefully, that majority decisions in those cases would cut away at or even overrule Chevron versus NRDC. Morgan, why didn't those hopes ultimately pan out?
Glenn, I think at this point, there are not enough justices who see a pressing need to revisit Chevron. And that is because they have, I think, made a couple moves that have really diminished Chevron's importance, at least in the cases that are at the Supreme Court. And I think that's sort of a big caveat, that as the Supreme Court has put Chevron in a smaller and smaller box, it's not necessarily true that all lower courts do the same. But at least with respect to the Supreme Court, I think it has really shifted when in the process it thinks about Chevron deference. Historically, some of the early cases, you come in, an agency says that a statute means something, and the court just says like, well, I look around and that's sort of within the realm of reasonableness. That's sort of on the spectrum somewhere, and that seems fine, right? And the agency gets a really heavy thumb on the scale straight out of the gates. And I think now the court is approaching Chevron more as kind of like a last step tiebreaker type rule. It's akin, for those of you familiar with sometimes how it talks about things like the rule of lenity or constitutional avoidance, that there needs to be a really serious problem, a serious ambiguity in this case before the court turns to Chevron. And frankly, a lot of the justices, especially those, as Shay has said, who are more comfortable with textualism, don't see ambiguity all that often. They have a lot of tools in their toolbox, a lot of canons of construction at their fingertips, and they march through all of these canons and employ all of these tools and come to what they think is the best reading. And that's what we saw happen in both the Becerra cases, both AHA and Empire, it came out different ways for the agency. In one case, the agency's reading was struck down, and the other it was upheld. But in both circumstances, the court just thought, I'm going to apply my tools of statutory construction, and I can see what the answer is here. And Chevron's not really making the difference. So I think it's generally made a move kind of to put Chevron in a smaller space. And then even within that smaller space, as I'm sure we'll talk about more, and as Glenn, you've already mentioned, the court now has the major questions doctrine. So even within that smaller space of, we're not going to find a whole lot of ambiguity. If we do find ambiguity on something important, well, the agency doesn't get to decide that either. That's Congress that needs to speak clearly. And so I guess between these two things, the sort of not finding a whole lot of ambiguity and not leaving important ambiguity up to an agency, the applications of Chevron just don't seem that troubling, even to individuals who might otherwise be concerned about Chevron. What's left is, in a truly, really ambiguous case, an agency gets to make a call on sort of smaller technical issues. And I just don't think, given that role for Chevron, that there's the same sort of cry to revisit it.
So in addition to being about climate change, which was a big sort of picture issue to begin with, there was quite a few big constitutional theories that came into play in West Virginia case, constitutional standing, Chevron deference, the non-delegation doctrine, and now this major questions doctrine. Amy, two questions. Were you surprised, first of all, that Chief Justice Roberts was the one who authored the opinion? And were you surprised by the way that he decided to deal with the question presented?
So no, I'm not surprised that he authored the opinion, and I think this is perhaps a good example that the predictions of, the death of the Roberts Court it may be not yet warranted. Certainly, he lost the conservatives in Dobbs, but he still has the assignment power, and he assigned the case to himself, and it allowed him to pick the lane that he was most comfortable with. It's one that gives opponents of agency action significant tools in the future, but it doesn't go as far as some wanted the court to go. And if he had given the case to someone else, we might have seen a different path chosen. Let me just give a little background for the audience, even though I'm sure most people know generally what the case is about. The general question in the case is whether the Obama administration's Clean Power Plan, which seeks to reduce carbon emissions from power plants industry-wide, whether it was consistent with the relevant section of the Clean Air Act. The opponents argued that EPA's authority extended only to regulating measures to restrict emissions at an individual power plant, what people refer to as within fence line measures, meaning measures within the fence lines of an individual plant and not industry-wide measures. There were a whole bunch of arguments available to the court on how to say that the Clean Power Plan was not consistent with the Clean Air Act. It could have invoked the somewhat dormant non-delegation doctrine, which would have held that the relevant provision of the Clean Air Act improperly delegated legislative authority to EPA, in which case the provision itself would have been invalid. It could have, just engaged in a straight up textual analysis, as it did in the Becerra cases, and held that no, as a matter of the plain text, the EPA's action was not consistent. It could have used the case to limit Chevron deference expressly, but it didn't take that path. Instead, what the chief did is to invoke what is now called the major questions doctrine. This is a doctrine the court, I think, has applied without calling it a doctrine in prior cases. This is the doctrine that Congress doesn't hide elephants in mouse hills. It doesn't give agencies sweeping authority in narrow ways. And so the court has applied that doctrine, but the court finally gave it a name, and it's now called the major questions doctrine. And what it means is that if Congress wants to give an agency power to make decisions of vast economic or political significance, it must say so clearly. It's essentially a clear statement rule. And that's going to give opponents of agency action, I think, a pretty potent tool in the future. in any case where agencies are taking major action. And given the state of Congress and its inability to confront what some might say are major questions, I think those kind of actions are going to fall more and more to agencies. And so this doctrine has quite significance going forward.
Real quick follow-up question, Amy. How much do you think Justice Gorsuch is sort of putting the meat on the bones of the major questions doctrines and his concurrence? How much is that going to be relied upon by litigants as they go forward and judges when they have to rule on these kinds of issues in the lower courts?
You know, Justice Gorsuch, I think, kind of explained the major questions doctrine as a corollary to the non-delegation doctrine and a way to avoid having to conclude that that a certain provision violates the non-delegation doctrine. So I'm sure that his concurrence will be impactful going forward, but I think the Chief's majority opinion gives litigants kind of all they need, even without Justice Gorsuch's concurrence.
You've argued some major cases before the Supreme Court and major questions, certainly. How do you see this sort of playing out going forward? Is this going to be a new sword for the administrative state opponents that the non-delegation doctrine didn't end up being?
I'm not sure I will say it's a sword, but it's like maybe the pocket knife version of the sword, or some smaller, more precise tool. Look, I think both of them, as Justice Gorsuch's separate writing indicates, although he mentions non-delegation a little less than I thought he might, both of them have the same animating idea, which is disciplining Congress. Congress needs to legislate when it comes to big issues, when it comes to policy decisions. That's not something the court is going to allow the executive branch to do unchecked. So they are getting at, in many ways, the sort of same separation of powers concerns. But I do think that the major questions doctrine is more targeted in a couple ways. The first is the result. This may be obvious, but under the major questions doctrine, there is a statute that stands, and the agency's construction of that statute simply doesn't stand. But Congress could always speak more clearly and get to the exact same outcome. Under the non-delegation doctrine, the statute as written, no matter if that is what Congress intended, is no good. It simply has chosen to leave policy question up to the agency, no matter how clearly, and that is not viable under the non-delegation doctrine. That I think relates to the second issue, is sort of the type of ambiguity here. The non-delegation doctrine is about intentional ambiguity in most circumstances. The major questions doctrine is more about, well, we're trying to, in some ways, effectuate Congress's intent. We didn't really think Congress is going to leave these issues up to an agency without saying so clearly. That's sort of the elephants in mouse holes idea. And then I guess the last distinction potentially is the size of the ambiguity. So the non-delegation doctrine could, at least in theory, apply to smaller issues where it's still clear that it's a policy decision being made, even if that policy decision is sort of in the agency's wheelhouse. Whereas the major questions doctrine, the court was trying, or at least I read the Chief's opinion as trying to emphasize that it's not going to apply every time the agency makes a call on something. It's really reserved for issues, truly of national significance, and issues where the agency feels like it's acting outside of its lane. We talk about this in the West Virginia case, that's a little less clear, but certainly with the OSHA vaccine case, that idea of an agency operating outside its lane on something with this at the scale of the US economy had some force. So I think all of those are kind of distinctions, but at the end of the day, the overlap that I see, and I hate to sound like a broken record, is kind of the overlap I saw with the narrowing of Chevron, right? The court is construing Chevron to do less and less, And so it doesn't really have a need to overturn it. I think in many ways, the major questions doctrine is going to draw back a lot on any need or perceived need to reconsider the non-delegation doctrine, because the biggest abuses, the stuff that we care about the most that Congress has sort of let the executive branch run free on, well, that's going to be cut back by major questions. And so maybe the court's just not that concerned then about revisiting the non-delegation doctrine, the sort of bigger fish.
Before we move on to other cases, any thoughts from you on West Virginia or the larger sort of doctrines that come out of this?
Well, picking up on something that Morgan said earlier, I think there's a lot to be litigated in the lower courts in the wake of this Supreme Court term on administrative law. It is remarkable, I think, that the Supreme Court did not even cite Chevron in any of these administrative law cases, despite hundreds of pages of briefing and lots of oral argument time being devoted to whether Chevron should be overruled. The Supreme Court simply ignored that outright. Now, of course, that's the Supreme Court's prerogative. I don't know whether lower court judges are going to feel as free to disregard Chevron. I also don't know that lower court judges need to disregard Chevron to do essentially what the Supreme Court has done, which I would analogize to a Chevron step one analysis. The Supreme Court, I think, is just finding statutes unambiguous more often than it might have before. And you can either think of that as Chevron step one, or you can simply set Chevron to the side and call that straight up statutory interpretation. And so I think it's going to be interesting to see how all of that develops in the lower courts. There was one very interesting oral argument question from Justice Gorsuch. I think this was in American Hospital Association versus Becerra. He asked one of the lawyers, if we look at a statute and we can see arguments on both sides, but we think it's 51-49 one way, what do we do with that? And I think the court's answer to that is 51-49 means it's unambiguous in favor of the 51. I think it's going to be interesting to see if lower courts pick up on that. Second point, in terms of the major questions doctrine and non-delegation, if you look at the key section of the West Virginia versus EPA opinion, it's only a few pages long, in which the Chief Justice sets out for the court what are the circumstances in which the major questions doctrine applies. And I think litigants are certainly going to push the envelope in terms of trying to get the major questions doctrine to apply to more cases. On the one hand, the court's opinion does say that it's only supposed to apply in exceptional cases. This is not supposed to be a run-of-the-mill tool. On the other hand, there are threads of that opinion, for example, that the major questions doctrine applies when the agency does something surprising, like maybe has a novel interpretation of a statute that's been around a long time. Is that enough to trigger the major questions doctrine? Again, I think the lower courts are going to have to grapple with all of this. There's kind of a feel to that section of the West Virginia versus EPA opinion that it's almost like if something that an agency has done, the court doesn't use this phrase, but shocks the conscience. Like, it's just so surprising to the court that OSHA would implement a vaccine mandate, or that the FDA, before a statutory amendment, would regulate tobacco. That's what triggers the major questions doctrine. But exactly what the boundaries of that are in the lower courts, I think, is very much an open question and creates opportunities for those who are challenging government regulation.
Question from one of our viewers, and it fits right into our discussion here, so I'll ask it now. With regard to Shay's analogy to Chevron step one, isn't that exactly what Justice Kagan did in considering a textual analysis that applies equally to Chevron?
I had the same reaction at the same time that question came in, which is, I think, yes. I mean, Justice Kagan said in the cases Kaiser v. Wilkie, we're going to apply every single tool we have to construe a statute, or in that case, a regulation, before concluding that it's ambiguous. And she, I think, suggested that courts have been too quick to find regulations ambiguous. I think what we're seeing now is the court using every tool it has to find a statute unambiguous, even if it's really kind of ambiguous, but it thinks there's a better reading of the statute. That better reading is now the unambiguous reading.
So moving on to some of the criminal law decisions, the court issued two on June 27th, one of which was successfully argued by Amy's colleague, Luke McLeod. Amy, how might Concepcion or Ruin impact white collar criminal enforcement and prosecutorial defense as well?
Sure. So I think Concepcion is fairly narrow. It involves the interpretation of the First Step Act's procedures for retroactive sentence modifications for defendants who had been sentenced under the 100-to-1 crack to powder cocaine ratio that existed before 2010. So I think, it's a fairly narrow decision. But that said, the decision is kind of chock full of the court expressing the view that courts have very wide discretion to consider, anything and everything in sentencing defendants and resentencing defendants. So to the extent there are, people out there watching who are dealing with sentencing, it's a decision to kind of have at your fingertips at that stage of the case. But beyond that, I think its impact is limited. I think Ruan is potentially more impactful. Ruan involved a provision of the Controlled Substances Act that makes it a federal crime, except as authorized, for any person knowingly or intentionally to manufacture, distribute, or dispense a controlled substance such as opioids. And the question in the case is whether the knowingly or intentionally mens rea of the statute applied to the except as authorized language, even though that language came before those mens rea requirements and the statute. The court held that it does, that to be convicted, the defendant must have intentionally or knowingly known that his conduct or her conduct was not authorized. And the court went on to further explain that once the defendant puts at issue the authorization exception by producing evidence of authorization, the government bears the burden to prove beyond a reasonable doubt that the defendant knowingly or intentionally acted in an unauthorized manner. And it got there by explaining that there's a presumption in the criminal law that the mens rea element applies to terms that separate wrongful from innocent conduct. And here, what really separated wrongful conduct from innocent conduct is the except as authorized language, even though there's other indications in the statute that the lack of authorization is not technically an element of the crime that the government needs to plead at the indictment stage, for instance. I think Ruan gives defendants a lot of creative arguments when it comes to the mens rea element and how the mens rea element applies across a badly worded statute, which unfortunately there are many of in Title 18. And so I think it is a tool in defendants' pockets going forward when it comes to mens rea.
The term is one intellectual property case, which was a copyright dispute, started out innocuously enough with respondent H&M waiving its right to reply to petitioner Unicolors. Court ended up requiring H&M to reply, and in the end, the court granted cert. Good number of amici participated, including the U.S. government. Morgan, what did the court decide here, or what impact might this have on creative industries?
Well, I don't want to overstate this case. This is not quite a barn burner in the IP world, although there are a few IP cases that the court has recently called for the views of the Solicitor General on that may be. So you may have a little more IP stuff to talk about this time next year. But with respect to this case, just to give the very brief backdrop, for those of you who don't know, copyright is automatic when you create the work. You have a copyright in something, but you don't have an enforceable copyright on which you could sue until you register your copyright. So you register your work with the Copyright Office. And then the question that arose in this case was, well, what happens if there's an inaccuracy in that registration? The statute says, and this has some parallels to the Ruan case Amy just mentioned, the statute says that you need an inaccuracy will not void the registration so long as it wasn't made knowingly. And the question there was, do you need to, does that mean only it's void if you knew that there was an inaccurate fact? Or what if you were unaware of a legal inaccuracy? In this case, that involved the problem that the application included multiple works together when those works were not a single unit. That's not acceptable for a registration. And so there was a legal error more more or less. Did that legal error void the whole contract registration and so eliminate the ability to sue? And taking a cue from some of the cases that it is talked about in the criminal context that involve some of these mens rea requirements, the court said you don't lose this for a mistake. You know, how important is that with respect to copyright registration? I mean, hopefully errors of law are not so plaguing these types of registration statements that it's, you know, it may not make a huge difference. But I do think that at a higher level, the case illustrates something, which is that the court has, I think, demonstrated a real respect for certain kinds of intellectual property like trademark and copyright, and is, I think, more receptive to policy arguments about not wanting folks who have those rights to lose the ability to enforce them. And so there did seem to be a real concern here at argument and the briefing about having a loophole where someone could lose their copyright rights. I think in the patent world, that is not always a narrative that works. There's this strong competing narrative of patent trolls that at varying points in the court's history sort of seems to have more resonance than others. But I think that this case, you know, to the extent you want to derive a bigger lesson from it, it's that I think some of these non-patent types of intellectual property, the court does have maybe a greater concern about protecting them, and the policy arguments can get you a little further in those sorts of cases.
So shifting focus a bit to specific justices, Justice Sotomayor wrote the most dissents this term, 24. Amy, I'd like your thoughts on something that the New York Times' Linda Greenhouse wrote about Justice Sotomayor, that she's adopted the role of writing alone to criticize the court when she believes the majority overlooks or misrepresents the factual history and context behind its often textualist opinions. What do you think about that?
Well, I think she's never shied away from dissenting or dissenting alone, even when she was on a 5-4 court and potentially had a greater chance to persuade the other side. She's never shied away from, I think, playing that role of the conscience of the court in dissent. I looked at the stats on SCOTUS blog and was interested to see that since OT 06, and she joined in OT 09, but the stats go back to 06, she's authored 16 solo dissents, which was second to Justice Thomas, not surprisingly. Justice Breyer had authored 8 during that time, and Justice Kagan had authored 0 solo dissents, which I think is a good illustration of the different approaches that those two liberal justices take. I think the best example of her dissenting in this way of calling attention to what she perceives to be kind of the factual inaccuracies in the majority opinion this term came not in a solo dissent, but in a dissent for the 3 liberal justices in the Kennedy case of the praying football coach, where she spent quite a lot of her dissenting opinion calling out what she viewed as the majority's selective recitation of facts, even to the point of including photographs in her opinion of the prayer sessions on the football field to show kind of the amount of attention that these were drawing that she thought was absent from the majority's opinion. So I do think that she does play that role. I think she will continue to play that role, and she will not shy away from doing that.
Justice Kavanaugh wrote the fewest majority opinions of all the justices, 5, but he was in the majority about 95% of the time, and he wrote some really notable concurrences. Morgan, any thoughts on his relative dearth of lead opinions, but notable joining opinions?
So I could get into some theories on the majority opinion assignments, like maybe he had a per curiam in January in the OSHA case, which came, you know, the stay was originally directed to him. And look, I could give you some inside baseball guesses, not from inside baseball from the court, just from reading all the tea leaves too carefully. But frankly, the majority opinion thing is, you know, it's not clear. We'd just be guessing, and it's pretty ticky-tacky trying to guess exactly why he's maybe one shorter there. The concurrences, though, I think there's some very important and interesting things there. Justice Kavanaugh concurred 8 times this term, which is more than anyone by several opinions, I believe. 3 of them, I think, were pretty standard. Zubaydah, Cumming, and Wooden, he wrote the type of concurrence I think we'd see from anyone. You know, this is my slightly different view of the law, and here's where I slightly depart from the majority. But then he has several others that I think are really unique and certainly reflecting a trend. It's obviously got the most attention in cases like Bruin and Dobbs, the gun rights case and abortion rights case. And I think to a lesser extent in some of the religion cases, and maybe even the migrant protection protocol return to Mexico case. But I think what he's doing in many of those concurrences is emphasizing the court's role, the narrowness of the court's opinion, the degree of agreement among the justices on the court, in a very particular way that you can pick up in case after case. And my sense is that there are really 2 reasons for this. One is that he's an institutionalist, and it reflects the desire to protect the court's integrity, reputation from what he knows is going to be an attack on the decision as politically based. And I think the other one is to try to set clear lines, especially for legislatures, whether state or federal, about what is still on the table after the court's decision. And so I think we see this, you know, Dobbs is a perfect example, right? He's talking about this is what is the court's role and what is not, and then what states might still be able to do and what things he actually thinks are foreclosed, even though those issues, you know, were not before the court there. And so I read that a little bit more as like a don't bother trying this, I'm the median justice kind of hint. But I think that the goal there, and I might be biased, I'm a former clerk who thinks very highly of him, but the goal in both of these cases is to allow some clarity going forward. I think that it's to preserve the court's legitimacy and to help legislators with their role to know, you know, just what a court did and did not decide in a 40-page opinion, to distill that down in a way that makes clear what avenues are still open.
Shay, after a year with another year of Justice Barrett on the court, is the court proving to be as much of a 6-3 business-friendly court as some had suggested it would be?
So I think consistent with some of what I was saying earlier, I think this court thinks of business issues differently than the Rehnquist court and maybe the early Roberts court did. I think in those times, the courts were certainly very focused on text, but I think they were also more willing than the current court to take into account the policy consequences of decisions for businesses, perhaps in the way that Justice Breyer's dissent in the Badgerow case that I mentioned earlier would have suggested. But I think this court is just much more textually focused. So in that sense, it is not as business friendly a forum if you're just trying to make business policy arguments. On the other hand, as we've been talking about with the administrative law cases, this court has a much more muscular view of the judiciary's role in policing both administrative agencies and Congress, for that matter. And so to the extent that businesses are heavily regulated parties, I think this court presents opportunities to challenge government regulation in a way that may be more successful than before.
Were there cases that the court didn't take this term, Shay, that you were kind of surprised that they didn't take in the sort of business regulation area?
Yeah, so there were a number of cases this term, a number of important business decisions that I thought, business petitions that I thought the court might well take that it didn't. Just to list a few, there were a couple of petitions involving the Fair Labor Standards Act. There's a circuit split about whether Bristol-Myers applies to collective actions under the FLSA, so that plaintiffs who are seeking to opt in have to demonstrate personal jurisdiction over their claims. There were petitions on this issue from both plaintiffs and defendants. So both the defense bar and the plaintiffs bar thought this was cert worthy. The Supreme Court denied it. United Healthcare versus Becerra was a case that was recently denied about whether Medicare Advantage insurers are subject to False Claims Act liability in certain circumstances. Lots of amicus support underscoring the importance of that case. And then preemption cases. The Monsanto case was about whether federal law preempted state law claims alleging that Monsanto had failed to warn that Roundup could cause cancer. The government had supported Monsanto in the Ninth Circuit. The court CVSG'd, the SG switched positions in light of the change of administration, and the court denied cert. And lastly, a case that I was involved with about whether the Airline Deregulation Act preempts California state wage and hour law, and particularly actually meal and rest break law as applied to interstate flight attendants. And again, the Justice Department had supported the airline in that case in the Ninth Circuit. The court CVSG'd, the government opposed cert, and the Supreme Court denied. So those are all some significant business cases that seem to me to be strong cert candidates. And from the outside looking in, I can only assume the court just didn't have an appetite for it.
In the Hardeman case that you had mentioned, as well as another Monsanto case, Piliad, as well as 3M versus Amador, those were all opportunities for the court to potentially weigh in on the so-called gatekeeping of expert evidence at the district court level. Are any of you surprised that they're don't seem to be interested in that just now? I know there's an amendment at 702 that's going to be going into effect, but we were kind of surprised that they didn't take up one of those cases for that reason. Anybody have thoughts on that?
I think
Okay.
just to add that if, especially in cases where there's been a CVSG, the government's recommendation is going to carry so much weight. The statistics vary administration over administration, but it's something like 80% of the time the court's going to agree with the government. That's a little bit one-sided. If the SG says to grant, the court almost always grants the case. If the SG says to deny, then it's about, it can vary 60%, 70%, whether it agrees with that. And so I think part of what's going on in at least some of these cases, like the Monsanto case, is if you don't have the SG on your side when the court is asked, it's an uphill battle.
I certainly think that's true. And I think if you look at the batch of CVSG briefs that the SG filed at the end of the term, I think there were 13 cases. The SG recommended deny in all but one of them, which was the American Axle case about patentability. And the Supreme Court denied cert in every single one of them, including American Axle, which I think was certainly surprising to me.
One of the statistics that really sort of stunned me, and this may be the way that it's always been, is that the court reversed or vacated lower court's decision 83% of the time this term, including 11 of the Ninth Circuit's cases, and kind of surprisingly, 7 of the 8 cases from the Fifth Circuit. Is this consistent with how the court, Roberts Court, other courts in the past, you have much better of a chance to win if you're a petitioner than if you're a respondent? Anybody who has thoughts on that one? I'm sorry, I didn't direct that to anybody specifically.
I mean, I think in general, yes, although when there's a circuit split, it could come up in either posture. And so it's a little hard to predict what the right percentage should be in those kind of cases where you have a broad circuit split, and it could come up in either one of the two postures. So I don't know how that number compares to prior terms.
I also think when a case gets litigated at the Supreme Court, you're taking an issue and you're putting it under such a microscope that the justices will often see aspects of the problem that maybe the lower court didn't. And so they're very likely to find a reason to send it back. That doesn't mean that everything the lower court said was dead wrong. It just means that they found something to disagree with and send it back on. And without having the statistics from previous terms at my fingertips, I do think that the affirmance rate has been historically relatively low.
Question for Shay, but anybody can answer this one. What's the court losing in Justice Breyer's retirement? And what is the court gaining in Judge Jackson becoming Justice Jackson?
So I'll start out. One thing that I thought was interesting listening to Justice Breyer give some media interviews about a year or so ago, after the end of the first term after Justice Ginsburg had passed away. He talked about the importance to him of being the most senior justice among the three more liberal justices on the court. And how, particularly at the justices' private conferences, as a result of being able to speak first among the more liberal justices, he was potentially able to float some compromises. And that particular term, unlike this one, was one that was characterized by a very high degree of unanimity or near unanimity and narrow rulings. So I think one thing that will be interesting to see is how the dynamics on the court shift with him no longer in that role. Obviously, Justice Sotomayor is now going to be typically the most senior of the more liberal justices. As Amy said earlier, she doesn't hesitate to speak her mind in separate dissenting opinions when she thinks the court is going the wrong way. I think Justice Breyer perhaps was a little more willing to compromise. And so I think one thing that will be interesting is to see how that dynamic shifts and where Justice Jackson fits into it.
I think for me, I'm eager to see what Justice Jackson's style is at argument, because I think everybody who follows the court knows and probably loves Justice Breyer for his unique style. But as an advocate, like, he really puts his cards on the table. You know, he is probably more than any of them, like, this is what I'm thinking. These are the analogies running through my head. Does this work or does this not work? Where would you disagree with what my train of thought is here? And so, we're not going to have that, obviously. And I don't know if Justice Jackson will follow the trend that is common sometimes with new justices, that they're a little more reserved their freshman year on the court. And if so, then I think we're going to have a real gaping hole in levity at argument, at least.
I'm really interested to see how Justice Jackson's perspective as a former federal defender impacts just the way she expresses herself in criminal cases, whether in the majority or in dissent. I just think it's impossible to understand the way that criminal law impacts defendants if you haven't been there in the trenches at trial litigating a criminal, defending a criminal defendant, and she's the only one of those 9 that has done that. And so I'm just really interested to see her voice in those cases.
I had read that Justice Marshall was the only member of the court, I think at that time, and still is, that had actually represented a capital defendant, and how that sort of animated his perspective on the death penalty. And I don't know if Justice Jackson has had the same experience, but certainly I understand what Amy is saying. I think is very sort of indicative of that it will definitely bring a different perspective on those kinds of issues. Finish up, I wanted to ask the panelists' thoughts on what looks to be shaping up as a more interesting October term 2022 for enterprise and for economic liberty. Amy, what are you most interested in, other than the epic Andy Warhol copyright case in which Williams and Connolly has a dog in the fight there?
I'm really interested to watch the Dormant Commerce Clause case, the National Pork Producers Association case. It involves the application of the Dormant Commerce Clause to a California law that prohibits the sale of pork from pigs raised in certain conditions. And because almost no pigs are raised in California, it almost exclusively governs pig raising outside of California. I'm interested to watch it, I think, for a reason that Shay touched on earlier, which is this court is just not the same court that we saw, during the Rehnquist years and the beginning of the Roberts years. When it comes to these kinds of issues, we were just reminded in very explicit terms in Dobbs that courts are not supposed to read things into the Constitution, and the Dormant Commerce Clause is not expressly in the Constitution. And both Justice Gorsuch and Justice Thomas have have expressed skepticism about the Dormant Commerce Clause. And so I'm just very interested to see how the right kind of approaches this case, because I'm sure from a kind of, policy perspective, they will have great dislike for this law. But whether they have 5 votes to overturn it, I just don't know.
Morgan?
Yeah, so I also agree that that's probably one of the big cases. But I think another one that I'll be looking at just to round out the circle from my original comments is this 303 creative case, which is in many ways the follow-on to Masterpiece Cake Shop from a couple of years ago. And it's another case where I think you look at it and it seems like it's sort of a hot button political case. And I don't mean to say that it isn't, but I do think depending how the court comes out there, it could have repercussions for business. So this is a case about the tension between a group that creates effectively sort of speech on demand in commerce and public accommodations laws that require that business person to provide that services to all comers. And it arises in the posture of religious obligations and same-sex marriage. But I don't think that if the court adopts First Amendment principles here based on freedom of speech, that it's going to be limited to that religious context. And so I think it could have implications if the court goes on sort of the speech side for the various freedoms that businesses have who operate in any creative space. And if the court goes on the public accommodation side, then I think it will have repercussions for a lot of businesses, because public accommodations laws are not always limited to the things that we often think of, like race, sex, sexual orientation, but a number of public accommodations laws extend to things like political affiliation or political beliefs. And so I think that companies will, if the court is really strong on public accommodations laws here, then I think companies are going to have to think and make sure that they're not getting into any liability on things that may not have been at the front of mind in a case like this. And so, nominally, again, it's like a hot button same-sex marriage and freedom of religion type case. But I do think what the court says on that tension between speech and public accommodations laws is going to have more wide-ranging business repercussions.
Shay, any thoughts on cases to watch the next term?
So I would echo what Amy said. I'm absolutely fascinated by this national pork producers case. As Amy said, Justice Gorsuch and Justice Thomas don't seem to think that the Dormant Commerce Clause exists. On the other hand, Justice Alito has very much embraced it. I think the Chief, Justice Sotomayor, and Justice Kagan appear to accept it. And we just don't know about Justice Kavanaugh, Justice Barrett, and Justice Jackson. So I think that's going to be a fascinating case. It was granted after being relisted 7 times, which is quite unusual and may suggest that the justices themselves behind the scenes are grappling with what to do with this case and don't really know how to predict the wide range of views that might emerge on this case. The 2 other cases that I'm watching are the Axon and Cochran cases. Just really briefly, the basic issue here is whether a constitutional challenge to agency procedures has to be brought before the agency itself in the first instance, or whether the challenger can go directly to federal district court. So I think those are going to be interesting constitutional and administrative law cases that will also have spillover effects for other agencies besides just the FTC and the SEC, which are the 2 agencies at issue in those cases.
Do you think that the court's acceptance of Axon and Cochran, even though they're at this sort of where can you bring the constitutional claims stage, does that reflect an interest potentially in the larger constitutional issues of the administrative, the way that the agencies are structured and the removal for ALJs and those sort of issues that have come up in other cases in the past?
Quite possibly, and there's also the Jarchese versus SEC case out of the 5th Circuit, which directly reached those questions. And I would imagine that there's a good chance the SG is going to take that up, in which case that would also be on the docket for the same term as Axon and Cochran. So we'll have to see the interplay among those cases.
Thank you, everyone, for joining us today. Thank you, Shay, Amy, and Morgan for taking the time to participate in the program today. Wish everyone a pleasant summer, and hopefully you'll join us again in September when we do our annual preview of the upcoming term. Thanks again.
Thanks, Glenn.
Thanks, Glenn.
You.